Shooting legal judgment to be corrected. I'm going to send it court.
She's pleading the one, and that's it.
That's all. Only one like that.
So,
Hey, watch out there.
Oh,
oh, no, Miss Newton, you here, you over there. Come up, ma'am.
oh.
Mr. Pons, you ready?
I need to sign, under sign on the plea.
Okay, let me get it done and then I'll bring her. Okay. And is this one not, this one's not even on the docket, I guess, right?
It's on the docket. Oh, that one case is not on the docket. Yeah. Sorry about that.
Okay.
Miss Williams, or what is your true name?
It's Williams Newton. Thank you. I brought my ID.
Yeah, I gave him his ID, her ID.
ID says Newton.
It's Williams.
So it says Chrysanthia
Williams Newton.
Williams Newton.
Newton.
Okay, so we'll do a name change to that, whatever that ID says.
Okay.
You were charged with 4 counts of, I'm sorry, with, is it 2 counts of theft?
3 counts of theft, 1
2 counts
failure
of
to ID.
and 1 failure to identify oneself, giving fictitious information. You need to understand, ma'am, is that when you have multiple thefts, at some point they're going to hit you with a felony and you're looking at days instead of years. The agreement that you've worked out is they're going to dismiss 3 of the cases for your plea on 1. You have 1 prior theft, and it's very possible your next one.
Did you catch that? The judge gave a clear warning, 1 more theft, and it's a felony. That means years behind bars, not just a slap on the wrist. What do you think? Should repeat offenses always get harsher penalties, or does context matter more? Drop your take in the comments.
May land you in felony court where you're looking at years instead of days. Do you understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record and you can never take it off. Do you understand? Like I said, 2 thefts plus when you get a new charge, a 3rd one, you're looking at a felony charge. Do you understand? They can use this to enhance your punishment. Not only that, from now on, you're looking at a minimum of 90 days in here for any new cases that you pick up. You understand? Do you still want to do this?
Yes.
How do you plead to the offense of theft, man? Guilty or not guilty? I will find you guilty, sentence you to 12 days in jail. I'll give you credit for the 4 days that you've done. Good luck to you, man. Please see the clerk. Okay, thank you, Mr. Pons.
For now, and I'll call you up to give your collection form, okay? Don't leave until I give you a collection form. I'll call you back up. Just have a second.
Okay.
You run the court cost. Okay.
If you're appointed, of course. This is a very interesting issue. I've really never run across something like this before, where they really have just out at the outset said, hey, man, if you blow and you're under, we're letting you go home, which is essentially what's happening here, right?
Yes, Judge.
Do you have any case law that says that it's okay to say that?
We have case law that says that the case that he used is overturned.
Judge, and we also have Sandoval v. State, which is from May of 2000 from the Court of Appeals of Texas, and it does.
You're saying May of 2000. When was this case?
I think that one's pretty old.
Oh, this is 95. Okay.
And it's from
What case do you have? Can I
Sandoval.
see a copy?
Yeah, you can keep that.
Oh, I think I actually, Judge, may I hand you?
No.
Okay.
They're talking.
Yeah. All right.
So Sandoval is almost the same thing as, or I forgot the last name, but
It's the same thing.
I already know your position.
so.
I'm trying to get theirs.
It states the same thing. And the officer in this case with the facts stated, if you blow under, you can go home. And the Court of Appeals held that the court did not abuse their discretion by letting in the breath test, that it was statutorily, it was outside the outside the statute requirements of the DIC reading, but that it didn't
A court found
directly
that was not,
abuse of discretion from the trial court. Yes, Judge. For Sandoval.
okay, so but they let it in.
Yes, Judge.
Right. But is there something that says if it's let out, it's an abuse of discretion?
That, no, it's just case by case basis at this point.
Is it?
Yes.
Okay. Okay. So, have you seen the cases that they cite here? Okay,
I know these cases. May I point something out to you?
sure.
Was that Navarro that you just read?
I think I'm looking at your Finian. I don't think it's on point. I mean, this is just whether this guy was more afraid about getting stuck by a needle, and that's why he wanted to blow as opposed to,
100%.
whereas this one's more on point where I think it go either way.
It's 100% on point. And then what I wanted to point out to you was, I believe that was Sandoval that you were just reading.
Yeah, Sandoval.
Okay, so in the in the Sandoval case, the court said the only case we have found, the only case
Right.
they'd found concerning this very specific issue, the validity of consent given the hearing consequences of passing felony.
Okay, legal nerds, here's where it gets spicy. The defense just cited a case, State v. Vandal, to argue that the breath test was improperly obtained. The judge looks intrigued but skeptical. Legal flex incoming. This all comes down to consent versus coercion. So what do you think, was the defendant pressured into blowing, or did he still have a real choice?
Breath test is State v. Sandoval. So they recognize that Sandoval is still good case law. They keep saying that Erdman overruled this case, and that's simply not true. This is still good case law, and I might also add Sandoval is in the Court of Appeals of Texas of Austin, and the case that I cited to you is the 14th Court of Appeals here in Houston, Texas.
Response?
Judge, nothing from defense. Sorry, from the state. It is really just
Yeah, I
something to consider for the court.
I'm ready to rule. I think it's totally coercive. Absolutely. I mean, there's just no, I've never seen something like it, statement that, so I'm going to get locked up regardless, right? If you do breathe and you blow under, I'll take you home. If you do blow over on breath, then you're getting locked up. All right, I'll blow. I mean, really. If you blow under, quote unquote, I'm taking you home. If you blow over, you're getting booked in. If you do blood, you're getting booked in regardless, because blood takes 3 weeks, a month to come back. Yeah, I think it's totally, yeah. All right, I'm going to grant your motion as far as the breath.
Thank you, Your Honor.
Okay.
And Your Honor, just to kind of maybe make this faster tomorrow, the state has also, we kind of touched on the motion in limine. And one of my motions in limine was to keep any testimony of the horizontal gaze and nystagmus, the eye test, out of evidence because it was improperly performed twice. Once, the HGN that was given might as well have stood for here goes nothing, because that's kind of what it looked like. And then the second time, the horizontal gaze nystagmus test was just murdered.
We agreed to leave it out already.
So, okay, but I just wanted to clear that up for the record.
So just, admonish your officer accordingly. Hey, please don't get into this, and then that'll make it smooth. And then, yeah.
Absolutely.
Okay. Anything else?
No.
No,
Okay.
and we also came, just for the record, we did come to an agreement as to
Is this smooth courtroom coordination or organized chaos? Both sides are tying up loose ends, redacting body cam footage, agreeing on test exclusions, and prepping for tomorrow. It's like legal Tetris. But here's a question. How much courtroom evidence do you think gets tossed on technicalities? More than we realize. Let me know your take.
where the body cam would be redacted.
Okay.
And the portion that is redacted includes some statements that were on defense's motion for limine. So it becomes moot at that point.
Got it. Just make sure you watch beforehand so that you're okay with everything, so that when we do watch, it goes smooth and we don't,
Yeah, if I can get a copy of the one that they're going to offer into evidence today, I can
Do you
review it
have,
tomorrow.
do you have one
I
here?
do, I do not have a redacted portion of the body worn camera right now, but I can get it to you by the end of today.
Yeah, that's
I
fine.
can send it to
That's
you.
fine. I'm good with that.
All right, guys.
Thank you.
Thanks.
See you tomorrow. Counsel.
Madam President, matter.
Yeah.
Cause number is.
Hi, Mr. Newley.
Good afternoon, Judge. So very busy today.
Almost done.
Cause number 2541895. That's Gascon.
Okay.
And Mr. Gascon is in the courtroom today. He needs to travel for his job and he's on the call-in, random call-in.
That
I
him over
spoke-
there?
That is him.
Okay.
I
So
spoke,
there's no travel restriction. If he gets called in to take a test while he's gone, he's going to have to go to a Quest Diagnostics, wherever he's located. Again, they're all over the country. I don't want Punka City Labs. It's got to be Quest Diagnostics, so it's ASCLD certified. We know that it's a legitimate lab. He gets the results to you guys, you get it to them, and then we're
Thank you, Judge.
thank you.
Say it again?
You want me to have like cases that are over 150 days after return?
No, 180.
180. Oh, 180.
Yeah, just, if it's at 150, just ask, is discovery complete? Because if discovery is not complete at 150, then we got a problem.
You could probably.
Whose plea is this? Do you know?
This one, this is Bernardo's yesterday, the one that was like last minute, but then we set for tomorrow. We're just waiting on Plaza. He's in that street.
Okay,
And she should be on the way.
So I got the panel outside, so I give him 5 minutes just to use the restroom.
okay. If you want to go ahead and let the lawyers know in the trial case, that there should be in one of the witness rooms that the panel is here.
Okay.
See if they're ready,
Okay. Yes, sir.
please.
What time do you usually can be taking a break? I'm sure I'll be back.
I don't know. Let's see what, I don't know if we're even gonna go because,
Oh.
so let me see
Okay.
if they can work something out. I don't know.